Good afternoon, everybody. I think thank you everybody for bearing with me and till half the day because I could not take this training in the morning. However, your training it's quite short because as you know, these are very short rules. You have barely, I don't know, 13 rules. So, and we don't need to go into all 13 also. I'll just cover the relevant portions. So, before I start, how many of you are familiar with these rules or tapaharle yo rules sanga deal garnu bhako cha? Can you just put up your hands? How many of you have dealt with it? Yes, okay, so apart from tapai 1, 2, 3, 4, 5 jana bhayo, the rest I think you're the only ones who will really need to know about it. I think most of the ADMs and SOs and court officers and all, they're quite familiar with it. Right? I want to ask those who are not familiar with it, tapai say your rules jun say Sikkim government servants discipline and appeal rules cha, यो चाहिँ को-कोलाई चाहिँ apply हुन्छ भन्न सक्नुहुन्छ? Who will it apply to? Can anyone volunteer and tell me who does it apply to? You're muted.
Government servant, ma'am.
Yes, unmute and kindly respond.
Staff members, ma'am. I believe all the staff members.
Okay, all the staff members. Do you think it will apply to, say, for example, Director Sir and me?
No, ma'am. No, ma'am.
We won't come under it.
I believe
we won't come under it. Tell me.
I believe judicial officers have their own set of rules, discipline and appeal rules.
We have our own set. The procedure, where do we look? Where do we see? Where do we have to look? I think you're getting confused. See, it is correct. The judicial officers, we have our own service rules, all right? But for all other purposes, for our salary, for our leave, for disciplinary action, we have to turn to the Government of Sikkim service rules.
Okay.
So, although even judicial officers, they have their own service rules, recruitment, appointment, amenities, we have our own rules, but even judicial officers will be subject to disciplinary action. It is not that disciplinary action judicial officers like other officers of the court also like everybody is subject to certain rules. I mean, discipline we have to show that make sure that everybody goes and behaves in a manner befitting of a government servant. So, being government servants, even we will come under these rules. And I have had the unfortunate, unhappy occasion of conducting certain disciplinary action under these rules, under various categories, from judicial officers right down to class 4 staff in the various courts, all right? So it is not that we are not covered by these rules. However, who is not covered by these rules other than the judicial officers? Can you, do you have any idea? Government servant, government servant, for example, say, our prosecution section, will they be covered by this?
No.
Police will not.
No, police will not.
Very good. So, servant, although they are also police, police are government servant, but these rules will not apply to the police. Anybody who is under the armed forces and police services. Because the disciplinary rules are very strict and they have a different set of rules. Right? So you must bear in mind that everybody else comes under these rules except for people who are in the police services or security services.
Yeah.
All right. So main thing about in this is your rules apply. When do we turn to these rules? Any idea? Would anyone like to volunteer? Just कसैको leave on leave application हुँदाखेरि we will turn to the leave rules, isn't it? These rules चाहिँ कहिले चाहिँ हामीले यो rule को पन्ना पल्टाउनु पर्छ भन्नुस् त?
During disciplinary,
The misconduct गर्यो भने misconduct गर्यो भने
Okay. So misconduct as why? How? This is when a government servant does not behave in a manner befitting of a government servant. When you do something that you should not have done, or you have broken the rules. And which is the rule applicable for that? Vannuska? Sikkim government conduct rules. So conduct rules. जब यो सिक्किम गभर्नमेन्ट conduct rules को कुनै rules चाहिँ तपाईले तोड्यो या if your authorities find that you have not conducted yourself as per these rules, then this rule will, then we have to turn to the discipline and appeal rules. त्यहाँदेखि चाहिँ concerned authorities ले चाहिँ के action लिनुपर्ने हो for the person's misconduct. That is when these rules will apply. अब यसमा चाहिँ one of the main people who will be dealing with the rules is the number one, appointing authority. I think ADMs, the two ADMs will be able to say for a different category of classes of our staff, who would be the appointing authority? Vannusta?
Decision session judge.
Yes, for the purposes of our establishment, the appointing authority will be the district and sessions judge. And the two conduct these rules. Disciplinary action लिनको लागि चाहिँ you will need a commission, you will need a disciplinary authority, you will need a presenting officer, you will need an inquiry officer, and there are सबै different categories of persons who will play their different roles. Action लिनको लागि everybody has their different roles, no? Starting with the appointing authority, then you have the disciplinary committee, then you have the presenting officer, you have the inquiry officer. In a सबै चाहिँ it is defined in the rules itself. Section 2 ले चाहिँ appointing authority बन्छ हो, who is a government servant, who is the commission, who is the disciplinary authority, who is the whose service is to be considered. It is defined under section 2. There are like other government departments, अरु सबै government departments को लागि चाहिँ the commission will be the, any idea? SPSC, no? Sikkim Public Service Commission ले चाहिँ यो सबै हेर्छ नि हैन? But our staff will not be covered by them. Our staff will be exclusively dealt with by our own disciplinary committee, which will be constituted in each district by the district judge or the appointing authority. So every court will have or has its own disciplinary committee. All right. And the त्यसमा चाहिँ if you will look at section 3 मा चाहिँ disciplinary action लिँदाखेरि चाहिँ के चाहिँ नतिजा हुन्छ? What are the penalties? Penalty माने punishment, no? बदमाश गर्यो, misconduct भयो, if you don't follow the rules, if you found that you have not behaved in the manner becoming of a government servant, then these are the penalties that you can impose on the government servant. And your penalties say there are two categories of penalties. One is minor and one is major. Alright? Minor ma ke आउँछ? Anybody? You all must have heard, no? Oh, it's like disciplinary action भयो, like यस्तो गर्यो, त्यस्तो गर्यो. Any ADMs, SOs, anybody would like to volunteer? Because you all have vast experience. In fact, more than the basic, they know all these details, no? So can you explain to inform them, your newcomers, what are the minor ke huncha?
Censors, madam. Then
Yes,
upholding.
promotion, yes. उसको अलिकति पे काट्न सक्छ, then increment we can deny increment, right? And this is minor, सानो punishment हो. What is यहाँ number 1 मा छ नि censor भने के हो? Censor को माने
Warning, madam.
yes, censor means warning. So this is the mildest form of punishment. फन्नाले बदमास गर्यो, लु उलाई एउटा वार्निङ लेटर इस्यु गरिदेऊ, हैन? That is your mildest form of punishment कि it is अलिकति you say tapping the knuckles भन्छ नि इंग्लिशमा, हातमा ट्याप्पै गरेर, हातमा ट्याप्पै with your ruler, केटाकेटी हुँदाखेरि ट्याप्पै हातमा हिर्काउँछ, हैन? It is like that. For a government servant, warning is like tapping your knuckles. First warning कि be careful है. Formally तिमीलाई warning दिँदैछ भनेर एउटा strict warning दिएर चाहिँ you pass a censor against the government servant, हैन? Or if you find it's a little bit serious, then के गर्न सक्छ? If he is due for promotion, then at the time of the consideration of promotion, if such a government servant comes under the zone of consideration, a promotion को लागि पनि अब एकजना मात्रै हुँदैन, हैन? You have certain category of candidates in the feeder post who will be due for promotion. त्यसमा यस्तो government servant को नाम छ भने चाहिँ you will not be considered for promotion, because त्यति बेला चाहिँ the service records will show that उसको against मा चाहिँ minor penalty भएको थियो, हो, उलाई चाहिँ यस्तो भएको थियो या उलाई यस्तो action लिएको थियो. So you will be withheld from getting any promotion, because the disciplinary action will have passed a order saying that withhold promotion in future. So in case the government servant is due for promotion by virtue of seniority or otherwise, then he or she will not be considered for promotion. Third is that उसको salary भएर कतै उसको कारणले गर्दाखेरि the government or your department has suffered some kind of pecuniary loss, then you can recover it from his salary. For example, let us say the drivers. We have had instances where drivers have been caught drinking on duty. They have banged the cars. अब गाडी ठोकायो, यो गर्यो, उले government property damage गर्यो. So this is an example. So the department incurs expenditure for repairing the गाडी, हैन? So if any action is taken against such a government servant, and if it is found that yes, he has caused the loss, about disciplinary authority finding दियो कि पक्का यसले गर्दाखेरि उसको negligence ले गर्दाखेरि he was found drunk on duty, it was because of him के भन्छ उले गर्दाखेरि यो गाडी ठोकायो, यो loss भयो, हामीले यति पैसा तिर्नु पर्यो, means then this is another form of penalty that can be imposed on such a government servant. You will recover that amount of pecuniary loss, financial loss caused to your court, which will be recovered from his salary. I think you पहिला शायद I don't know गरेको पनि होला, है? Then finally we can withhold increment. Every year, government servants like के छ, पाउनु के छ, हैन? Apart from your DACA, assured thing is that you will get your increment, हैन? Every year. अहिले त कहिले हो? It's in June, July, no? When is it? Nowadays? July, हैन? Nowadays, it's standard thing कि July मा everybody will get the increment. So everybody expects, it's expected, given कि July मा मेरो increment पाउँछ, हैन? But if there is a finding by the disciplinary committee that the government servant has been found guilty of any misconduct, then you can give an order saying that increment rokno. You will not be entitled to increment. So this is the loss you will suffer. But these are minor losses, minor punishments. All right? And these kind of punishments, there is a long history of government servants who have suffered these kind of punishments. Even in this court, till just year before last, I think we had to withhold increments of some staff because of disciplinary proceedings. All right. Then comes the major penalty. These are in more serious cases, ekdamai grave action liyo bhane chai, then you can take major penalties. Major penalties ma chai ke garna sakcha? Can you tell them idioms? Mute. You're muted.
Termination.
Ekta, you can
Demotion, madam.
Yes, you can do demotion. Then scale घटाउन सक्छ हो.
Yes.
Retirement, compulsory.
Compulsory retirement.
Yes. Ekta you can scale घटाउन सक्छ, grade घटाउन सक्छ, post घटाउन सक्छ हैन. So that for a government servant यत्रो दुःख गरेर काम गर्दाखेरि कोही बेला अलिकति यो scale goes up, grade goes up, or promotion भएर post goes up, and so when action is taken decreasing that itself is ekdamai shameful. We consider it a shameful thing, and that is why it's considered a major penalty. Like a demotion गरिदियो ला, scale घटाइदियो, grade घटाइदियो, post धराइदियो. अब कतिवटा cases मा grade 4 staffहरु from other posts they meet के भन्छ सफाई कर्मचारी, or they were reduced to the lowest post possible because ekdamai badmas garera. There's a history of such action taken also from the high court to the, I don't know, district courts ma चाहिँ गरेको छ कि छैन, but I am aware that this has happened in the past. So that is how these are the major penalties that can take place, right? And then you have compulsory retirement also.
Yes.
भएन अब त्यो मान्छेलाई चाहिँ लु छुट्टी, अब compulsory you retire them off, or remove them from service. But there is one thing, compulsory retirement is finished. When you remove them from service, there is one provision which says it will not disqualify him from trying for another government job.
Okay.
That is also there. That is one penalty that can be imposed. But other penalty is that normally if you are dismissed from service, then you will be disqualified from, obviously, other departments, they will not take you, no? So it will be considered a disqualification from future employment with the government at least. So these are the major penalties that can be imposed, right? Now, basically, this is the only thing. The rest of it is procedure.
Yes, procedure.
The rest of it is procedure about what to do. Ab yo penalty impose gardakiri chai, next thing question will come, kole गर्ने? हैन? So normally what happens is there's a disciplinary authority. You can look at rule 4. Rule 4 ma then यो penalty भयो अरे यस्तो किसिमको punishment दिन सक्यो अरे भनेर 3 will talk about it. Now rule 4 मा चाहिँ कसले चाहिँ गर्ने? It says who. So normally this can be imposed by the appointing authority. है? तर जब appointing authority आफैले यो inquiry गरेन भने चाहिँ you can appoint a inquiry officer, and then you have the entire disciplinary authority. है? So appointing authority normally गर्दैन, किनभने what happens is the government servant might want to go in appeal against the order passed by the disciplinary committee. हैन? So normally say appointing authority will say कि I'll appoint so and so to conduct the inquiry. So that person will conduct the inquiry, and your inquiry officer will be one person appointed by the appointing authority. It is say like a case, no? Appointing authority, appellate authority bhanau na, हैन? Then you have the inquiry disciplinary authority, inquiry authority, and that your case present गर्नको लागि on behalf of the department कि लु फल्ना फल्नाले यस्तो बदमास गरे यो गरे त्यो गरे यस्तो गरे भन्ने एउटा मान्छे त चाहियो नि हैन so that is called a
Presenting
exactly presenting officer to present the case अब त्यो जुन गभर्नमेन्ट सर्भेन्ट माथि एक्सन लिँदैछ उसको केस चाहिँ यस्तो हो भनेर इन्क्वायरी अथोरिटीलाई प्रेजेन्ट गर्नको लागि चाहिँ देयर हैज टु बी अ प्रेजेन्टिङ अफिसर सो एउटा प्रेजेन्टिङ अफिसर पनि यस्तो इन्क्वायरी गर्दाखेरि अपॉइंट हुनै पर्छ सो one will be a presenting officer one is of course the inquiry officer then the government servant himself can के भन्छ come and be heard. All right. Now the main thing, whether it is a disciplinary action, whether it is a tribunal ko order, consumer ko court house, of course normal court ma to hunai parcha. What is the main thing that you must bear in mind? Number one, you all keep hearing, natural justice, bhन्छ नि. What is natural justice? Natural justice चाहिँ जस्तै किसिमको सुनाइ होस् त्यसमा चाहिँ you must always remember rule number 1 is that never pass any order, never conduct any proceeding in the absence of the other person. If you do that, the whole order, whole procedure will be vitiated. त्यो चाहिँ illegal हुन्छ. It will be set aside. आँखा चिम गरेर appellate authority will say wrong. So anytime you conduct a disciplinary proceeding, you must hear both sides. दुई पार्टी हुनै पर्छ. एक पार्टी absent भयो भने चाहिँ no matter how closely you have followed the procedure, no matter how careful you were about your documents, no matter how badmash the government of a servant was, the entire proceedings will be vitiated. It will be considered wrong. So, every hearing on every order must be passed in the presence of the, at least notice dinu paryo, usko presence ma garnu paryo. In case notice diera त्यो person आएन willfully, jani, you are aware that that person did not want to come, has willfully absented, ekdamai knowing the date is fixed, he did not come, then you can proceed like other cases ma हामी ex parte गर्छ. But otherwise it would be illegal to give any order against any government servant. All right. So now, so basically more or less that is the thing. Now what is the role of an inquiry officer?
Fact finding.
Inquiry officer को के गर्नुपर्छ?
Fact finding.
So inquiry officer ले चाहिँ त्यो सबै कागज पत्र बनाएर चाहिँ अब प्रेजेन्ट गर्नु पर्यो हो. Presenting officer ले दिइसकेपछि चाहिँ inquiry officer must make sure that he gives sufficient time for hearing on both sides. Okay, दुईपट्टिको hearing गर्यो र is there a period of limitation? Yes, no?
3 months.
Yes, within 3 months from date of first hearing.
Yeah.
So you have to conclude the matter, हैन? तर के हुन्छ भने कति चोटी चाहिँ it's not possible. You will not. Some you will finish within 3 months. Some you might not finish within 3 months. But in case you are an inquiry officer and you did not finish it within 3 months, so what do you do?
And you delay specification.
Yes. So you must give reasons. Like in a court, you all सधैँ तपाईहरुले सुन्नुहुन्छ हैन? Reasoned order हैन भने चाहिँ it's a wrong order, it will get set aside भनेर. So even in your orders, when you're giving date or when you're not able to finish within 3 months, you must give reasons.
Reasons.
Reasons say frivolous हुनु भएन, हावाको reasons हुनु भएन. You must have sound reasons कि यो कारणले गर्दाखेरि या the government servant चाहिँ बिमार भयो या presenting officer बिमार भयो या त्यस्तै landslide भयो, hearing हुन सकेन, whatever the normal reasons you have, but which are good reasons, you can give that. And maybe your appointing authority like bhanera chai you can get your time extended, all right, because that has happened in the past also. We did not finish a certain inquiries within 3 months. Now, supposing the inquiry officer is a rank, inquiry officer is a rank below the government servant who is being inquired into, can he conduct the inquiry? What do you think? Supposing the government servant say gazette officer, and inquiry officer is not is below him in the rank, so to say. Can you be inquiry officer? Usko inquiry garna sakcha?
No, I don't think. We don't think.
Okay, so now in this regard, there is a specific provision that is 5G. Look at 5G.
5G vision.
Oh, okay. 5G.
Would you like to read
State
it out?
inquiry.
No.
Yeah, conduct disciplinary procedure. Any game.
A state inquiry officer will be competent to conduct disciplinary proceedings against gazetted officers irrespective of the rank of such gazetted officer proceeded against with.
See, so it will not be a bar. So the government officer cannot say, supposing the government servant say, government officer, he cannot say, "Are you are lower than me in rank. How come you are inquiring into the matter?" If the appointing authority has made you the inquiry officer, you have every right. You are empowered by this provision to conduct the inquiry. All right. So because sometimes they will take this plea. How come? That is no, that they cannot do because there's a specific provision. All right. And then, normal government departments must say the state inquiry officer must belong to the Department of Personnel. This will not be applicable 5H and all because we are from a court, so we will follow our own, not the procedure, but we have our own officers. So we don't need to go through SPSC or the Department of Personnel. Everything will be done internally. All right. Just in the case of judicial officers, the appointing authority is Chief Justice, no? Yes. So Chief Justice will appoint, for example, in a particular matter, Chief Justice said that okay, you District Judge West will be the inquiry officer. And you, CJM so-and-so or JM so-and-so will be the presenting officer. All right. But the gazetted, but the officer who was being inquired into is another officer from the state judicial services. Like that. So it can be held in this manner, okay. Now, inquiry officer, let's say, finding the nusaksa, right? But can the inquiry officer impose the penalty?
No. No.
So what does the inquiry officer do? Inquiry case you have done, you have found competent, you have heard matters, then what will you do?
Report submit.
Yes, then you will give your finding, eventual finding, but you are not authorized to impose penalties. All right, but you will say whether you have found ground against the government officer to for action to be taken or not, or whether to charge. I'll come to charges later. Charge say prove you have to be clear. All right, उसलाई जे आरोप लागेको छ त्यो आरोप त्यो चार्ज विषयमा चाहिँ whether you found material or not. Okay, now to do this, how will you find out? How will you come to your order, give your finding whether there was material or not as inquiry officer? How will you give your finding?
Based on the facts.
फ्याक्ट्स हेरेर डिपोजिसनहरु गर्नुपर्यो, विटनेसेसहरु एक्जामिन गर्नुपर्यो.
Exactly, very correct. So like in a court, but not so formally, like in a court, procedure is basically more or less the same. You must have a fair trial. It's like a fair trial. Both parties will be given opportunity. You will start from stage 1. Just the criminal trial ma tapaiko charge huncha ni charge.
Yes, yes.
Similarly, about the presenting in this case also the government erring government servant ko against ma you will have the articles of charge. Oh, you will have the substance of the articles of charge. त्यो सबै in detail बताउनु पर्छ है, detail मा लेख्नु पर्यो. What is the complaint? First, for a charge to be framed, there has to be a complaint, like an FIR. कसैले त आएर कम्प्लेन गर्नु पर्यो नि अथोरिटीलाई कि फल्ना फल्नाले यस्तो गर्यो भनेर. On the basis of that complaint, if you find that it should be inquired into, then this thing, the whole ball will start rolling. Inquiry officer set up, appointing authority will appoint a inquiry officer, presenting officer. Then once the inquiry starts, then inquiry officer ले चाहिँ के गर्नु पर्यो, त्यो articles of charge बनाउनु पर्यो, presenting officer ले present गर्नु पर्यो detail मा, and every copy every charge or article framed will be given to the other side. जस्तो accused लाई दिन्छ हैन, same एक set उता दिनु पर्यो. They will be given an opportunity to reply हैन, त्यहाँदेखि they will be given an opportunity to present their evidence. So as inquiry officer, if you feel that I need documents for in support of this, or I need proof, कसले देख्यो, यसले बदमाश गरेको देख्यो, कसरी देख्यो, कहाँ देख्यो, if the presenting officer has the witnesses to present, then you can examine. But to be fair to the other side, you must inform them कि these are the witnesses, उनीहरूले यस्तो यस्तो ल्याउँदैछ, so that he can get an opportunity to cross-examine also, no? उनीहरूले पनि एउटा मौका पाउनु पर्यो नि त हैन, कि सोधपुछ गर्नको लागि कहाँ देख्यो, कसरी देख्यो, तिमी चाहिँ कहाँ थियो हैन. So all that, so basically a fair trial. है, उतापट्टि विटनेसहरु सुन्यो, यता उता गर्यो, त्यो articles of charge. Now articles of charge or बनाउनु, त्यो procedure कस्तो छ, it is all, I will not, because that is very technical, but it is given here in your rules. From 6 onwards, you can see the entire procedure. All right. Okay. So this is the procedure. Our trial कसरी हुन्छ, normally like a case only. You can do, all right. Now there is one provision here which is Rule 8, which deals with suspension. Achha, when can a government servant be suspended? Anyone? हामीले we always hear no फल्ना त suspend भएछ भन्छ नि, suspend भएछ. This entire यो appeal को rules मा चाहिँ उलाई चाहिँ कहिले चाहिँ suspend हुन सक्छ, किन चाहिँ suspend हुन्छ?
एरेस्टहरु भयो भने
हजुर,
डिपार्टमेन्टल इन्क्वायरी,
पुलिस केस, क्रिमिनल केस,
कसले चाहिँ suspend गर्न सक्छ? Inquiry officer.
appointing authority.
Yes, so it has to be the appointing authority. It has to be your district judge, basically. Put it very simply, court it will be the district judge who will be authorized to suspend the government officer, government servant. Call me suspend गर्न सक्छ. कहिले चाहिँ suspend गर्न सक्छ?
क्रिमिनल केसेसहरुमा पनि फस्नु फसेको छ, या त इन्क्वायरी भन्दा अगाडि
Any disciplinary proceeding.
Okay, very good. So now you look at it. Everything, whatever question we ask, it actually the rules will answer it. The rules will answer it. See, A1A. When a disciplinary proceeding against him is contemplated or is pending. Contemplated or is pending. अब जब appointing authority koma kura ayo, complaint ayo, they are thinking about taking disciplinary action against the government servant. At that stage also you can suspend. Mane, the complaint is so serious that you will feel that it's like the disciplinary action linu parcha. Bhanne bittikai you can suspend at that stage, right? Or if it is pending, it is not necessary that disciplinary action hunu parcha, then matrai suspend hunu parcha bhaner. When you are even thinking about taking action, disciplinary action, you can suspend him at that stage. But sabai case ma you don't suspend at that stage, haina? When can you suspend? Supposing a government servant committed murder or is found involved in a case of rape, complaint bhayo, ulai arrest bhayo re ulai information ayo from the police to the concerned district judge ki tapaiko staff yesto bhayo is involved in this matter bhanyo bhane. If the district judge feels that yes, you can immediately suspend at this stage. All right.
Okay.
I don't know how many of you know, Paila, there have been many cases where government officers were involved in cases of murder and rape. All right. So then what happened? Immediately they were placed under suspension. Departmental inquiry, it will come much later, no? Because against matter, what is happening? Criminal trial is being conducted, isn't it? So disciplinary proceedings, so they don't wait till the disciplinary proceedings. In such cases, immediate suspension. So that is why it says when it is contemplated or is pending. Of course, criminal arrest hone bitike after 48 hours, obviously they will be suspended, isn't it? When a government servant is locked up beyond 48 hours. Okay, Aina?
Yes.
Okay, so these are most of the 8 AMA you have from the date of his detention, if he is detained in custody, whether on a criminal charge or otherwise for a period of 48 hours. See? So 8 AMA, if criminal detention bhayo you can be suspended. Alright? Usko against my investigation you can be suspended. Apart from this, if complaint comes to the authorities ki ule against the interest of the state, anti-national activities garyo hare, terrorist activities garyo hare, testoma complaint ayo bha immediately you can suspend the government servant. In case he is not suspended, then from the date of conviction, it says with effect from date of his conviction. If in the event conviction for an offence he is sentenced for a term of imprisonment for 48 hours or more. So basically, since it is tomorrow is second Saturday, I think many of the staff want to leave, the ones in the districts might be wanting to go home. I will not take further time, but more or less, if you know this is the basic framework, if you try to apply these rules, and then while doing the while conducting such disciplinary proceedings, or if you are facing any disciplinary proceedings, then these are the factors to be borne in mind. And I would advise all of you to go through the rules, because every stage articles of charge कसरी बनाउनु, के स्टेटमेन्टमा के हुनु पर्ने हो, inquiry officerले के गर्नु पर्ने हो. And my advice is, apart from what is there in the books, it is always advisable to consult someone. Of course, not on the decision or your findings. That has to be totally independent and impartial. If you are alikati doubtful also about the procedure, then I would advise you to, because the rules are not comprehensive. They don't, they cannot anticipate every kind of situation. Cover SPSC is the department for the entire government which deals with these things, or somebody in the personal department, home, so procedure, if you are stuck or are in doubt, always consult somebody who is an expert in this field. Because courts most of the time we thank God we hardly ever do DIs. I know. But if in the event you are faced with a serious, of course we do minor ones, but if in the event you are faced with any serious DI, then you can consult if you are in doubt. Otherwise, you look at the past record, because the procedure is always laid down for the courts. You can always look at the past record. Okay. So, any questions and answers? Questions? Director sir, would you like to add anything more to this before we wrap up?
Ma'am, I want to ask one question, ma'am. Ma'am, you suppose एउटा ड्राइभरले हाम्रो अफिसकै ड्राइभरले गाडी लडायो
Before you go, just let me say again, like in all other trainings to police officers, pending case we will not discuss, all right? Any cases of DIs pending, we will not discuss those cases, okay? All right, Bim, now you can carry on.
अफिसको ड्राइभरहरूले गाडी लडायो उनीहरू चाहिँ आइपिसीमा बुक भइरहेछ या त अब 279 परे जेसुको बुक भइरहेछ म्याम र अलरेडी उनीहरूको केस पुलिस केस
Sorry, it's echoing.
कन्टिन्यू गरौँ
अच्छा यो can you repeat उनीहरूको केस हुँदैछ है गाडी लडायो अनि
गाडी लडायो उनीहरूलाई केस पुलिसले टेक ओभर गर्यो क्रिमिनल केस स्ट्यान्ड भइरहेछ र चाहिँ म्याडम क्यान द डिपार्टमेन्ट अगेन हामीले डिपार्टमेन्टले इन्क्वायरी गर्नु सक्छ या त त्यही अफेन्सको डबल के गर्न सकिन्छ भने हामीले क्रिमिनल केस त अलरेडी स्ट्यान्ड भयो
कन्भिक्सन भयो
कन्भिक्सन भएन कि ड्यू टु सच एन्ड ससिजन फेलियर अफ सच एन्ड ससिजन यो फाइनल रिपोर्ट बुझायो म्याडम त्यसमा चाहिँ हामीले इन्क्वायरी गर्न सक्छ कि छैन डी गर्न सक्छ कि छैन
There is no bar to a DE. There is no bar. Because it's the sunny, till such time he was under suspension.
No, ma'am.
He was not suspended.
I गरेन भने म्याडम सपोज गरेकै छैन
हैन उलाई चार्जशीट हुँदाखेरि सस्पेन्ड गरेन
गरेन म्याडम
Okay, now you want to do DI. अब जब यी फाइनल रिपोर्ट भइसकेपछि चाहिँ
म्याडम मैले भन्नुपर्छ कि एउटै अफेन्समा सपोज पुलिस अल्सो टेक ओभर द केस क्रिमिनल केस भइरहेको छ र हामीले डिपार्टमेन्टले डी गर्दा एउटा अफेन्सलाई दुईटा पनिशमेन्ट गर्न सकिन्छ म्याम त्यस्तो हुनु सक्छ
look at 8 your rule 8 को बी हेर्नु त उलाई सस्पेन्ड गर्न सक्छ हो त्यसको बादमा you can do your DI after conviction also.
If the accused is convicted, if the
John, if he is not convicted also you can do. This will not amount to double jeopardy. I don't know. That is what I feel. Director, what do you say? Because this is not double jeopardy according to me, because departmental inquiry is your jurisdiction, no?
Yes. Madam, there are n number of judgment and law is very clear. Even if the criminal court convicted that particular employee, and if the department is not accused or convicted, department is not satisfied, court is not satisfied, there is no legal bar to initiate judicial proceeding. Department, this disciplinary proceeding. There is no bar.
बार छैन कन्भिक्सन भइसक्यो भए पनि चित्त बुझेन यु क्यान स्टिल डु
Yes. Absolutely correct.
फाइन मात्र लगाए अरे कोर्टले फाइन मात्र लगाए अरे न डिपार्टमेन्ट इज सेइङ अरे यो त सारो सेन्टेन्स त्यो भयो यदि त यति डिपार्टमेन्टलाई यस्तो भयो डिपार्टमेन्ट क्यान स्टिल कन्टिन्यू इन्क्वायरी
Yes.
If police don't do anything about it, you still can do your inquiry. There is no bar.
Yes, madam. Absolutely correct. That is not binding. Yes, madam.
What about the question?
Yes, AGM query is now, police has now acquitted, the court has acquitted, police has filed the final charge sheet. Even in criminal matter also, even if police file final report, it is up to the court and complainant. Similarly, here also, it is up to the appointing authority whether to accept or whether to initiate this proceeding or not. There is no legal bar.
See, I will tell you, why is there a provision like that? Why so, Vannata? Because the fact that there was a criminal proceeding initiated against this government servant, uslai police ko inquiry bhayare. Another matter that police finally reported. The fact that there was a complaint against him and police inquired means he has put himself in a position where he did not conduct himself that was required as a government servant. One of your case conduct rules ma ke cha? In the very beginning, what did I say? Why do we turn to these rules? When you do not conduct yourself as befitting a government servant, when you are a government servant, you are expected to conduct yourself in a certain manner in society, behave in a certain manner in society. The term used is unbecoming of a government servant. You have behaved in a manner unbecoming of a government servant. Mani, as a government servant, you are supposed to behave. You did not behave. So, when the fact that there's a police inquiry against you, and then the police actually had a trial, no matter final report, the authorities, if you feel that the government servant should not have behaved like that, inquiry police complaint feeling you can still inquire into you can still have a disciplinary inquiry and you can take action against him. Why? Because he conducted himself in a manner unbecoming of a government servant. Matera gari kudayo. पहिला हाम्रो कोर्टमा we used to have a driver no Rambadur. Raile vamu tikjukko नालीमा लडिरहेको हुन्थ्यो हैन. Everybody used to say, कोर्टको driver. So that was, he used to behave in a manner unbecoming of a government servant. Say, okay, all right yes. Then. Anything else? I think everybody is hungry and ready to go home now.
No, the reason for now organizing this particular training program to our officer and official is that we have two administrative officer in 2 districts only. So far, the north and now these other 3 districts are concerned. Now the concerned immediate officer is required to prepare all these documents because district judges and the civil judges, they will remain always busy with judicial work. And they have to see the provisions, they have to prepare the documents, they have to issue the show cause, they have to issue the charge, they have to issue the memorandum, all these things, everything is there in this particular book. And so far the record is concerned, these district judges, I think they do not have record also. You can seek necessary instructions, support from this east and south, and you have to prepare. And so far this evidence now, this inquiry officer and presenting officer is required to know is that what is the quality of evidence required to be proved in this particular disciplinary proceeding is this. like a civil suit case only. Beyond reasonable doubt is not necessary. And so, what is preponderance of probability? You have to read, and read. And at the time of now, if you are not satisfied with so cause reply, you have to examine the document, then only place before the concerned HOD, saying that so cause reply is not satisfactory. There are enough incriminating evidences which we can prove against him. Then only you proceed ahead. Disciplinary proceeding gare 3 महिना 2 महिना अनि ultimately not able to prove it कस्तो हुन्छ हाँसउठ्दो हुन्छ हैन त्यसकारणले गर्दा इट्स ड्युटी अफ अल एटीएम्स एसओ कोर्ट अफिसर्स एन्ड सेक्सन अफिसर्स system administrator to go through the documents. And so far the probation is concerned, though there is no specific rule in these subordinate court rules also, as well as in Sikkim Judicial Academy rules, but in High Court, Rule 7C says that immediately the concerned authority can terminate. But here
we don't have.
What is required to be done, as already now this flown from the learned resource person, we have to comply the nature of justice. Then even those probational officers, the probational staffs is concerned, we can just issue so cause notice, given opportunity, comply the natural justice, but finish. Then now appeal provision is also there. That is not concerned with us. So far district is concerned, the appeal always go to the Honorable High Court. So only my request is, as in when any matters disciplinary proceeding lengthy छ जान्दैन त्यस्तो हैन तपाईहरुले चाहिँ disciplinary proceeding जहाँ गर्नुपर्ने छ without shouldering that particular responsibility on the head of the HOD, you have to prepare these particular documents, you have to prepare the papers and place before the competent authority for necessary orders. Do so cause disciplinary proceeding गर्नु भनेर त्यसमा 15 दिन 20 दिन हैन 2-3 दिनमा रेडी गरिहाल्नुस् हो यो बुझ्नुको लागि तपाईहरुलाई यो जान्नुको लागि के गर्नुपर्छ डिसिप्लिनरी अथोरिटी इज नट ग्रे एरिया यो पार्टिकुलर ट्रेनिङ प्रोग्राम कम्पिटेन्ट अथोरिटीले तपाईहरुको सुविधाको लागि गराइदिनु भएको हाम्रो सिनियर मोस्ट अफिसर इन डिस्ट्रिक्ट जुडिसियरीको प्रिसियस टाइम हामीले पाउनु पाएको र तपाईहरुले यसमा मलाई आशा छ कि तपाईहरुले निश्चय नै यसको फाइदा उठाउनु भयो र के पनि क्वेरी छ तपाईलाई के पनि बुझ्नु भएन भने सिक्किम जुडिशियल एकाडेमी एज अ लर्नेड रिसोर्स पर्सनले सोध्न सक्नुहुन्छ र I think with the permission of learned resource person, I have to close this particular session. And first of all, I, on behalf of Sikkim Judicial Academy, would like to offer my sincere gratitude to the learned resource person who has taken a precious time and made a very remarkable and wonderful contribution to all our officers and staff of the district judiciary. And I think, I hope and expect that whatever deliberation which the learned resource person has made to all of us here would definitely help to discharge those natures of function in days to come in our respective courts. And I equally would like to offer my sincere thanks to all officers and staff for successfully participating in this particular program and their remarkable feedbacks and enhancing the elegance of these practical programs with esteemed presence. Lastly, I would like to offer my sincere thanks to all technical manpower of all districts and as well as Sikkim Judicial Academy for rendering their wonderful this contribution to make this practical program a great success. With these words now, with the permission of learned resource person, I'd like to close this particular session. Thank you so much. Thank you.
Okay, thank you, everybody. Have a good weekend.
Thank you.